record with Mr. Christopher Lewis.
Yes, finally. Sorry,
I have received this motion, and I read the first couple of lines of it,
and they sucked.
and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case if you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
Uh-huh. Sure, we can do a spin of the propeller. Why not? Why Judge Perkins pretends to read this pile of dew. Oh, sorry, I didn't have the beginning straight. I thought Griffin was the guy. If someone would have just told me a guy looks like Bob Marley, we would have gotten right to the right spot. Well, thank you, Chelsea. I'm sure I look fantastic.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
Written articulation.
I'm denying the motion.
I would just appreciate a written excuse.
Denied, it's crap.
Can I get a written articulation?
I might give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Oh, here we go.
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
He doesn't need an excuse. He just made a ruling.
You're asking for a change of venue. I'm denying.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying a motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Yeah.
Okay. I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing. That's so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that. So I'm just asking that you can give me a written excuse that I could go take and complain against you on.
He's asking
because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming. So at the end of the day, like I said, there's no crime. This is a fraudulent charge. Y'all don't have, there's no suspect. Y'all suspecting for no crime. There's no victim, no losses. Okay. And in a minute, this is going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm gonna go to the tenor without it and let them know that you refuse to give me a written excuse, and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest. You only here to make money, man. You know what I'm saying? It ain't no crime. Ain't no victim or no loss, bro.
I'm not. Listen. I'm not your man.
Look, sir. Hey, sir. Respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody. I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more.
All right, bring him up. It's cool. I appreciate it. This is due process. This is a due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever. Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
I appreciate that, but I was still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not I'm not even going to hold you to that, but in paragraph 2. Moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make a determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages/losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge
No, he's denying the motion. I see a little confusion in the chat. He's denying the motion. The case goes to
trial.
trial.
Copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you coming down.
The 36th district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is a distinct.
Yeah, I was told to call the clerk the day that I was locked out. The moment I was locked out.
We've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you another.
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
It looks like it's going to be July the 23rd.
Before you say that again, Ms. Mathis, just verify it before you say it. Please, the dates.
Okay, I'm just checking.
I know, but you're thinking I'm one.
Okay, I'm sorry.
Good day.
Yes.
July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that date. So you're trying to play with me. You could dismiss it today, sir. You literally.
You'd like him to
You are literally violating my due process. You can't even give me a written excuse, but you're gonna all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. I do. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial of
I
July
am. It's all good.
22nd.
I am.
The date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
I don't know. Mr. Lewis, I'm sorry. Have a very good day. Best of luck to you.
For once, the SovCit was right.
Let's go move on.
You just said the wrong name.
Put him out the room, please.
Right.
Let's go with Goodson. You talked to Goodson, Miss Harris. All right, let's go back.
I did.
Well, that was absolutely fantastic. He should have been held in contempt, in my humble opinion. But whatever. The judge didn't want to do that. He just wanted to get him out to a jury. Hopefully that thing goes. If that thing goes, please somebody remind me. I definitely want to stream that if it happens. He is. I always say that every time you see a SovCit, you think it's the dumbest person you've ever met. But then, if you go through the SovCit videos, they're all that stupid. They really are. This guy's a special breed. This guy's a special breed. Zombie Bob Marley is top notch SovCit. Yeah. He. The judge confused everybody by saying he was dismissing the motion, which is technically not right, but used often in court. Like everyone understands what he means. He was denying the motion. and then the big dummy's like, I know what you're going to do. You're going to dismiss the case on the pretrial, which is precisely what he just asked for. He's not going to dismiss the case. But if he did, you'd like it, dummy. Oh, my God. I don't know where to begin. And then, of course, they all want to go to federal court. But, of course, 99% of these SovCits are involved. Not always. We've seen them in real estate and family law stuff. But generally speaking, they're in criminal matters. And criminal matters are, by and large, a function of state statute. So they end up in state court where they damn well belong. So unless if you shoot somebody on the, in the Capitol, well, that's going to be federal jurisdiction because you're on federal land. So there's analogs to all the crime statutes and everything for federal law, but you have to have some reason to get into federal court. So, by the vast majority of criminal activity is going to be prosecuted in the state courts where it belongs. They think that it's so funny to see them. They always want to go to federal court. They don't really care about federal court. It's just not where they are. That's why it's just a different place. But they always want to assume that somehow it's like it's better. It's not. It's just it's the same attorneys. Okay, like I generally practice in state court, and then sometimes I have cases in federal court. It's the same freaking people. There is no whit of difference between the Code of Federal Procedure and, say, the Illinois Code of Civil Procedure, for instance. I've dealt with both of those. There are little differences or whatever. You have to cite different rules or whatever, but like in substance, it's the same. And with all this other stuff, so they're always, it doesn't matter, but they're always pretending they just want to go to federal court, and in federal court they can do whatever they want. It's just not like that. It's not like that. It's not. They're wrong too. They're wrong as a matter of law, as a matter of constitutional law. Under the 10th Amendment, these things are left to the states to deal with. But even if you were right, getting to federal court wouldn't make a damn bit of difference. If for some reason we found out, okay, why he committed this offense, there was some federal angle so that he had federal jurisdiction, he would go to federal court and be convicted just as he would in the state court. Because he's guilty. Oh, good times. Thank you all for coming out. That developed why I was stuck in state court, namely Chancery Division, on a deck action. Let me tell you all about my deck action. You guys will be fascinated. All right. I guess I won't. All right. Thank you all for coming out. I appreciate it. I will see you all soon.